Good afternoon, everyone, and welcome. The Thurgood Marshall Moot Court Competition, formerly known as the Frederick Douglass Moot Court Competition, has been a virtual part of NEBLSA's programming since 1975. As a national competition, it is considered one of the most respected moot court competitions in the United States. And each year, law students across the country participate in 6 regional competitions, and the top 3 teams from each region advance to nationals. This year, the Northeast Region Black Law Students Association is proud to host this year's virtual competition. This year's problem brings awareness to legal issues within the transgender community, specifically preoperative male to female transgenders who are inmates at an all-male state prison. The issues on appeal to the Supreme Court of the United States are whether a defective complaint due to a plaintiff's failure to comply with the exhaustion requirement found under Title 42 USC 1997E, a provision in the Prison Litigation Reform Act of 1995, may be cured by filing an amended complaint after his or her release from prison. And secondly, whether a state inflicts cruel and unusual punishment in violation of the 8th Amendment by declining to provide sexual reassignment surgery to a transgender inmate. And at this time, I'm so happy to announce our esteemed panel of judges. First, we have Justice Kathleen Collette Waterman. Justice Waterman is a presiding judge in the Family Court of the State of New York, Kings County. Welcome, Judge Waterman. And we also have Chief Justice Levice Crawford. Major Crawford is a deputy staff judge for the 1st Special Operations Wing in Florida, responsible for leading 28 legal professionals, providing legal advice to the 1st Special Operations Wing commander and 66 subordinate commanders across 4 wings. Thank you both so much for being here. So excited to have you. This is an esteemed panel. And with that, we're going to go ahead and start the competition. Good luck to the competitors. Oyez, oyez, oyez. All those who have business before this Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Waterman and Crawford presiding. Do the petitioners now want to reserve any time for rebuttal?
Yes, please. 2 minutes from my argument for issue 1.
Okay. Okay, so if the petitioners are ready, you may proceed.
Madam Chief Justice, may I proceed?
You may.
Madam Chief Justice, and may it please the court, my name is Jocelyn Sanchez, and I, along with my co-counsel Mary Young Jones, our team OP, and represent the petitioners Thomas Turnkey, Maximus Vartanian, Oliver Rutowski, and Dr. Liam Walsh. I will address the issue regarding the amended complaint, and Ms. Young Jones will address the 8th Amendment claim. Your Honor, we recognize that the respondents have changed their names, and so we like to refer to them as Storm and Love and use she and her pronouns if that pleases the court.
Yes, so granted.
Furthermore, I'd like to reserve 2 minutes from my argument for rebuttal.
You may.
Thank you, Your Honor. The case presented before the court today asks whether the exhaustion requirement of the Prison Litigation Reform Act, or the PLRA, precludes respondents from curing their original defective complaint simply by amending it after release from Buckhead Correctional Institution, or BCI. We respectfully urge this court to overturn the appellate court's judgment on Storm's claims and Love's 8th Amendment claim and affirm the judgment for Love's original claims. Your Honor, before I proceed, would the court like a brief statement of the facts?
No, thank you.
Regarding the amended complaint, we will first argue that the PLRA expressly requires exhaustion of administrative remedies at the time of initial filing. Secondly, that Rule 15 does not and should not invalidate the text of the law. And lastly, that even if we turn to policy rationales, Judgment for respondents would set a dangerous precedent that would contradict the congressional intent and purpose of the PLRA. As a matter of statutory interpretation, we must first turn to the text and the language of the statute. Prison Litigation Reform Act states that no action shall be brought with respect to prison conditions under Section 1983 of this title or any other federal law by a prisoner confined in any jail, prison, or other correctional facility until such administrative remedies as are available are exhausted. Now, this language was evaluated in its entirety in the decisions of Harris versus Garner and May versus.
Counsel, can you give a legal authority that would support your argument that this court should ignore well-settled authority that Rule 15 amended complaint supersedes a complaint? Where exactly in the statute does it mention whether or not an amended complaint is controlling?
Your Honor, the statute does not expressly prohibit or expressly mention that Rule 15 does not apply. In fact, I don't think many statutes have that express prohibition or mention. Rule 15 is a governing body of law, so does every other federal law, and these do naturally function together. So
what legal authority would support your claim that we should ignore well-settled authority that a Rule 15 amended complaint supersedes a complaint, and that therefore the status of the respondent should be determined at the time of the amended complaint? What case or what part of any statute would support your argument?
Sure. So the statute mentions no action shall be brought. Now, this court, the Supreme Court, used in the decision of Goldenberg versus Murphy and decided on the meaning of the term brought. And it held, and I quote, that a suit is brought when in law it is commenced. And we see no significance in the fact that in the legislation of Congress on the subject of limitations, the word commence is sometimes used, and at other times the word brought. In this connection, two words.
I like to direct your attention to the Wolf case, where courts have historically looked at the status at the time of the amended filing. And at the time of the amended filing, wasn't Ms. Storm no longer an inmate at the correctional facility?
That is correct, Your Honor.
So that means that the provisions in the policy that you cited are no longer applicable, correct?
That is not entirely correct, Your Honor, because the Prison Litigation Reform Act expressly says the term brought, which refers to the time of commencement in a suit. Now, this court, the Supreme Court, has definitively addressed this issue. And under Rule 3 of the Rules of Civil Procedure, commencement occurs after the filing in court and is followed by issuance of summons. But you do mention other cases where statutory defects have been cured by amended complaints, except that in those cases, those refer to different types of federal laws. Because one, they do not contain the same language as the PLRA. Two, they do not impose a specific status on the plaintiff independent of the claim. And three, are radically different in nature. The PLRA was a specific law that embodied the exceedingly high number of frivolous lawsuits that were brought to court primarily because of the relatively easy access and high incentives that prisoners had to courts. Prisoners do not have the
Counsel,
same.
in this specific case, Ms. Storm and Ms. Love went to the warden to address the concerns of harassment that they were being subjected to. And days after they made that complaint, they were severely beaten in their cells by the same persons in which they were filing the complaint against. So why is the fact that the complaint was not written, the warden was still put on notice and had an opportunity to exhaust administrative remedies?
You are correct, Your Honor, but there is a purpose for formal grievance policies, and that is to provide a useful administrative record that in case the state cannot remedy such grievances, by the time the case arrives to a court, the court can effectively adjudicate the case for its merits. Also, the fact that if we just go based off of informal conversations between the respondents and the warden, we'd be coming down to a question of he said, she said, and simply hearsay. The purpose of the formal grievance policy is to provide evidence, is to create that record, which the PLRA contemplated in its enactment. But you also bring up a
Counsel,
good.
you're saying that a conversation between an inmate and a warden of a correctional facility is informal, casual conversation, and that conversation could not be taken on its merit.
It can be taken on its merits, but it would make it the job of a court much harder to adjudicate. There is a reason for formal written grievance processes. In fact, there is strong discouragement against informal conversations so that these types of situations do not happen. But the question at hand is whether the amended complaint can cure that initial failure to exhaust such remedies. And you bring up a good point, Your Honor, because a large purpose or intent of the Prison Litigation Reform Act was to deter not just frivolous lawsuits, but to also promote judicial efficiency. And so the question is not whether the claim has merit. We trust that a court can discern whether this is a meritorious claim or not, but we must remind ourselves that the court has every other federal law and every other citizen of this country to preside over. Pro se litigation presents particular challenges to the court, including the fact that pro se litigants are not trained in the law, nor in the court system. In fact, judges find the hardest time just simply discerning what claims are being brought and whether they're meritorious or not. And
Counsel, you still haven't answered my question as to what part of the statute, other than focusing on the word brought, what part of the statute specifically permits this court to overlook well-settled authority that a Rule 15 amended complaint supersedes a complaint? Because if a Rule 15 amended complaint supersedes a complaint, then necessarily that means that we are bound by the amended complaint. And at the time the amended complaint was filed, in this case, as to this respondent, she was no longer a prisoner within the meaning of PLR. So the statute doesn't apply. So where can we even, we have a threshold problem of how are you getting us to consider, because all of your argument is based upon the fact that we are looking only at the complaint as opposed to the amended complaint. And you still haven't demonstrated what law, whether it's statutory or case law, that would allow us to do that.
So, Your Honor, in both Harris versus Garner and May versus Segovia, the two courts or the two circuits address this issue. And we understand that there is a circuit court split. But the purpose of Rule 15 was to provide amendments that provided changes to substantial allegations or facts. Rule 15 includes Rule 15C, which would suggest otherwise to the notion that an amended complaint can supersede the original complaint for all purposes, because Rule 15C contemplates that if an amendment complaint were to exceed the statute of limitations, then it must relate back to the original timing of the initial complaint. So while an amended complaint can supersede the original for purpose of fact or allegation, which we should note does not exist in this case, because the
Counsel, no, isn't the crucial fact here is the prisoner's status. That's the fact. And this is not a relation back case. This is not a relation back case.
It is not a relation back case. And that is the point, Your Honor. The point is that this claim, the amended complaint includes an additional claim for respondent Love, which is one, completely unrelated to the original claims of the initial complaint, and two, relate to respondent Love, who is not the same respondent claiming exemption from the PLRA. I'd like to remind you that it's respondent Storm who's been released from prison, not Love. And so that change in the amended complaint does not meet the typical or what you've noted as well-settled authority are substantial changes to initial complaints.
But I was addressing, and I thought you were addressing respondent Storm's reinstated complaint.
Yes, for respondent Storm's reinstated complaints, there have been no changes. It's the same mirror carbon copy. The only change to the amended complaint was an additional claim related to respondent Love, not related.
Sorry, I'm confused. I'm conflating the respondents. Conflating the respondents.
Sure. No, it's there's two respondents. It's respondent Love, who is still incarcerated, And it's that change that was actually made in the amendment. So the initial complaint mirrors the exact amended complaint, just it's the 8th Amendment complaint, Your Honor. But just briefly to continue and remind the court again that this court has definitively addressed the meaning of the term brought that refers to the initial filing. Rule 15 can supersede, but not for purpose of timing. We've established that because if so, Rule 15C would be meaningless. And so we'd like to conclude and remind the court that Justice Robert Jackson, who presided in this very court prior to the enactment of the PLRA, said, and I quote, "It must prejudice the occasional meritorious application to be buried in a flood of worthless ones. And he who must search a haystack for a needle."
Counsel, I appreciate your recitation of the finding in that particular instance, but what I want to address in the last couple of minutes that you have before you have to conclude is the fact that Clark or Miss Storm is no longer incarcerated. So the administrative remedies that would be available under the PLRA no longer apply to Miss Storm. So why, help me understand the posture that you're taking as to why we should consider applying a statute that is no longer applicable because she is no longer incarcerated.
And Your Honor, the simplest answer is that because the Prison Litigation Reform Act requires exhaustion of available administrative remedies to occur at the time of initial filing. That did not occur in this case, and an amendment does not change that.
But weren't they silenced?
Administrative remedies be exhausted before an action is commenced. Respondents fail to do so, an amendment does not change.
You may.
Good evening, Madam Chief Justice, and may it please the court. My name is Mariah Young-Jones, counsel for the petitioner, and today as part of Team OP, I will be addressing the 8th Amendment issue. We respectfully urge the court to reverse the 14th Circuit Court of Appeals ruling on the unconstitutionality of a state prison withholding sex reassignment surgery to a transgender inmate pursuant to the 8th Amendment. Your Honor, the crux of this case is relatively straightforward. The legal standard for determining whether a prison violated the 8th Amendment asks whether the prison acted with deliberate indifference to a prisoner's serious medical need. We contend that in this case, the Buckhead Correctional Institution did not, and in fact was highly sensitive and responsive to inmate Love's medical needs. We also contend
So walk me
that
through the factors that are required to establish deliberate indifference.
Yes, Your Honor. So the Estelle versus Gamble test for a violation of the 8th Amendment first asks whether a prison inmate has a serious medical need, and secondly, whether a prison acts with deliberate indifference to that medical need. And we use the Farmer versus Brennan test, which asks whether the prison had subjective knowledge of that risk of serious harm, whether it disregarded that risk and acted with more than gross negligence to further qualify that deliberate indifference standard. And we would like to.
Didn't the prison know that that the respondent had suicidal ideation and was threatening to castrate herself?
Absolutely,
over the course of a long period of time.
Yes, Your Honor, and we do not dispute on that subject that gender dysphoria is a serious medical need. The circuit courts have spoken almost unanimously on this point, and we understand and appreciate the gravity and physical anguish associated with gender dysphoria. But the second prong of the Estelle test, which is where the bulk of this debate lies, it asks whether the prison officials were deliberately indifferent to prisoner Love's serious medical need.
Well,
And
Counselor, couldn't it be a question of fact as to whether is it disputed that the prison officials knew about the WPATH recommendations? Did they know or did they not know about the recommendations by WPATH?
I believe the record does not support or deny whether the prison officials knew about WPATH, but
And
we'd like to
So wouldn't that be, first of all, a question of fact as to what they knew about the recommendations by an organization that specialized, that this is what their work is? And secondly, whether those recommendations would have provided for the SRS, the surgery that the respondent sought?
Your Honor, we contend that WPATH standards of care does not set the constitutional bounds of adequate care for gender dysphoric individuals. The court should not replace longstanding legal precedent that has not paid deference to WPATH standards of care with the particular opinions of this singular medical institution. This is not, we contend, a beneficial use of the judicial system.
But isn't it true that the court often looks to industries and industry practice and medical expertise in certain areas?
Absolutely, and this is exactly what has occurred here. So if we turn to the facts specifically, we do know that upon respondent Love's diagnosis with gender dysphoria, BCI provided Love with hormone replacement therapy, gender affirming undergarments and feminine hygiene products, and makeup. These treatments actually went above and beyond the BCI policy for gender dysphoria.
Counsel, but even after all of those things have been provided to Ms. Love, she is still having suicidal ideations and threatening self-castration. So under the deliberate indifference standard, talk to me or explain how BCI has not been deliberately indifferent.
Because deliberate indifference asks specifically whether a prison official disregarded the risk at hand. And this
That's
is not
one
what
factor,
happened.
Counsel, of three.
It's one factor.
Correct.
I do want to also concede that prison officials, of course, had subjective knowledge of the risk of serious harm as well. We're not contesting that. We believe that the diagnosis of gender dysphoria, as well as respondent Love's ongoing struggles with mental health, would clearly establish that they had subjective knowledge of this risk. But they did respond to this risk by providing a tailored treatment plan to address.
So, Counsel, you're saying that provision of feminine hygiene products, women underwear, and makeup is sufficient to correct a gender dysphoria problem when the respondent, Ms. Love, is threatening self-castration and suicide?
Your Honor, in addition to those treatments, there was also the treatment of hormone replacement therapy, which is a very serious course of treatment that can change a recipient's entire body and body makeup.
But it has been inadequate thus far.
And Your Honor, this is where I disagree. There's no proof that the treatment has been inadequate. Very reputable medical institutions.
That Ms. Love continues to threaten self-castration and suicide?
Your Honor, these were medical conditions that respondent Love had prior to her treatment and after receiving treatment. But because gender dysphoria is a highly individual type of medical condition that patients can experience different to be tailored to the specificities of an individual's medical need.
So,
And
counsel, so
it's
wouldn't that support what the circuit court did, which was to find in effect by reversing the district court that there's a question of fact? I mean, would you have us craft a rule that says as a matter of law that recommendations under WPATH or SRS surgery is never appropriate? I mean, all the circuit court did was remand the issue to the district court so that summary judgment wasn't appropriate, but the issue could be fought out in the trial court below. Are you asking us to craft a rule that says as a matter of law, this SRS is never appropriate, even under these circumstances?
No, Your Honor, that is not what we're asking today. What we are asking is for adequate deference to be paid to a medical provider's discretion. Here, Dr. Walsh, who presided over Respondent Love's care, decided that SRS was possibly a premature move. Respondent Love has been receiving hormone replacement therapy for 3 years, but reputable medical institutions, such as the Mayo Clinic, have noted that feminizing hormone replacement therapy, which Love was prescribed, can take up to 5 years to take full effect, especially for results such as body hair thinning and body fat redistribution.
And we're now in year 4 of that for Miss Love, and she is still threatening self-castration, having suicidal ideations. So isn't that sufficient evidence to suggest that the hormone therapy is not working?
The hormone therapy has simply not run its full course of treatment. And hormone therapy, I should note, is, as set out by WPATH and other reputable and other medical authorities on the subject, a prerequisite for sex reassignment surgery. So it is important that hormone.
Doesn't the policy in which Miss Love is receiving treatment allow for supplemental treatment if the treatment plan established is inadequate?
Yes, it specifically provides for supplemental treatment plans as needed, and that is exactly what BCI has provided. The enumerated policy options in the treatment policy for gender dysphoria do not include the provision of, for instance, gender affirming makeup, but BCI has decided to provide those because BCI recognizes that social transitioning is an important part of treating gender dysphoria. None of us are doctors here. We are lawyers who apply the law.
In fact, counsel, on that point, you've raised an important point earlier, which is that the prison relied upon its doctor to make a determination, which it is entitled to do, but doctors often, and sometimes, well, not often, but sometimes make mistakes. That's why we have medical malpractice claims. And that's why plaintiffs, petitioners, like respondents, bring actions, and they're entitled to a trial on the issue of reasonable care, etc. So it sounds in some way that your argument is that we should, that the doctor was within his rights or his determination not to provide the supplemental care. But isn't that a trial issue? Isn't that something that's not ripe for summary judgment? Isn't that something that a trier of fact should decide?
Well, no, Your Honor, specifically because the deliberate indifference standard does not, as set out in Estelle versus Gamble, has made very clear that medical malpractice does not rise to the level of deliberate indifference. This is stated in the opinion of Estelle versus Gamble.
Counsel, but how is it not more than gross negligence in this case when the treatment plan provided is insufficient? There is a supplemental treatment option available, which the policy allows for Miss Love, and your clients are opting not to offer that treatment to her, which is in the form of SRS.
Your Honor, our clients have, again, chosen to allow hormone replacement therapy, which is, might add, a very serious course of treatment that, again, can provide very significant results and changes in a
But that's a
patient's
part of the
body.
normal treatment plan for gender dysphoria, according to the policy. It's thorough mental health evaluation, counseling, and hormone therapy. That's the basic standard of care for GD, for gender dysphoria. But
Correct, Your Honor.
it's not working for Ms. Love.
That is not up for us to decide. Again,
But is it
hormone
not
replacement
gross
therapy-
negligence to allow for supplemental treatment in the form of SRS when you have Ms. Love threatening self-castration and suicide?
It is not gross negligence for a prison to be responsive to a prison inmate's medical needs and to respond with the treatment that they decide is adequate at their discretion. And by that also abides by medical authorities' notions of what does constitute adequate treatment. There is a deeply problematic issue with using WPATHs as the de facto constitutional standard for adequate care. WPATH itself acknowledges that in reference for treatment for gender dysphoria, quote, "This field of medicine is evolving. And within this evolving medical field, the court has no place in choosing sides, especially when there is so much documented dissension within the medical community regarding the WPATH standards of care, as well as the use of SRS to treat gender dysphoria." In fact, Gibson versus Collier quoted a key medical expert who had drafted the 5th edition of WPATH, who said, quote, that WPATH was not a politically neutral document, and that WPATH
Understanding that, counsel, I appreciate the direct quote, but what I really want to focus on is this deliberate indifference issue, because I'm having a lot of difficulty in finding that your client is not being grossly negligent by not providing a supplemental plan. And to your point, counsel, you said that this is an evolving form of treatment. And this wasn't even an option available to Ms. Love when she was initially incarcerated, and it now is. So why wouldn't we provide, or why wouldn't the treatment that is necessary to treat the gender dysphoria be provided?
This is because, Your Honor, and I see that my time is up. Can I take a moment to briefly conclude?
Absolutely, you may.
Thank you. This is because, Your Honor, the deliberate indifference is a very high legal standard. It does not encompass medical malpractice claims. And in this case, Your Honor, BCI has responded to prison inmate Love's serious medical need with a tailored medical plan that is still playing out. Respondent wants to stretch the well-defined limits of the Estelle versus Gamble test to pay heavy deference to a highly disputed and arbitrary medical standard. And if the court adopts this new standard, it could create a slippery slope for what constitutes deliberate indifference. This court should reverse.
Sorry.
Yes, Your Honor.
I know we extended your time, but I do have one point that I'm still struggling to hear an answer to, because as you said in the beginning, you're not asking us to craft a hard and fast rule, and I don't know that that's what the circuit court did. And to my colleague's point, Madam Chief Justice, the issue really is whether or not it should go to a trial, and whether or not deliberate indifference and all of the attendant issues that are subsumed in there, shouldn't that go to a trial? Shouldn't that be, all of your arguments support remanding the case back to the district court for a trial?
Your Honor, we believe that there's no genuine issue of material fact that BCI has broken the law and has violated the 8th Amendment, and that's why this case should not go to trial. This court should reverse the decision of the appellate court and affirm the ruling of the district court. Thank you.
Thank you, counsel.
Thank you, petitioners. And now the respondents may proceed.
Madam Chief Justice, may I proceed?
You may. Good evening.
Good evening, Madam Chief Justice, and thank you. May it please the court. My name is Crystal Kong, and my co-counsel is Miriam Asheniga. Together, we are Team EF, and we represent the respondents, Dallas Storm and Amina Love. Today, we ask this court to deny the petitioner's motions for dismissal and for summary judgment. Regarding the motion to dismiss, this court is deciding today on the issue of whether Storm's failure to comply with the exhaustion requirement of the Prison Litigation Reform Act, also known as the PLRA, can be cured by her filing an amended complaint after her release from prison. I will be discussing this issue, and my co-counsel will be discussing Love's Eighth Amendment claim and the associated petitioner's motion for summary judgment. The petitioners have moved to dismiss today on the basis that the respondents did not comply with the exhaustion requirement of the PLRA, which requires that prison litigants must exhaust all available administrative remedies prior to filing suit. This motion should be denied because any failure to exhaust here was cured when Storm filed her amended complaint after her release from prison. Amendment in this manner is permitted.
Counsel, but in this case, when Ms. Storm filed the complaint, was there a written complaint or grievance filed with the warden?
Madam Chief Justice, in this case, Storm did not file a written complaint with the warden. The respondent spoke to the warden about potentially filing a written grievance procedure.
But doesn't the policy of the New London Department of Corrections require filing a formal grievance?
Your Honor, in this case, the question at issue is whether or not that formal grievance procedure that is listed in the prison's that was listed in the prison's grievance procedure policy was actually available on a factual basis to the respondents. In this case, the respondents met with the warden. The warden informed them of what the grievance procedure was on the books. Yet within days of their conversation with the warden, in which they simply suggested that they may choose to file a grievance against the correctional officers, the correctional officers, who are petitioners named here, went into the respondent's cell, brutally beat them, sodomized them, and then later lied about these events in their official incident report, stating that they had received a tip saying that there were drugs in the respondent's cell. Yet the COs also failed to recover.
Counsel, I'm very familiar with the facts of this case, and in no way am I trying to minimize the severe treatment that both Ms. Love and Ms. Storm received. However, you said days after the verbal complaint with the warden was filed, they were severely beaten, but there were also days after this incident occurred where they had an opportunity to file a formal grievance, and they did not do so.
Madam Chief Justice, it is true that the respondents did not file a formal grievance in this case, but
So they didn't allow for the exhaustion of administrative remedies, which is required when an inmate files a complaint.
No, Madam Chief Justice. In this case, as this court found in Ross versus Blake, the PLRA contains itself its own textual exception to mandatory exhaustion. That is, remedies must be available to the respondents for them to exhaust. Otherwise, by definition, the respondents cannot fail to exhaust remedies that haven't been available to them. In this case, the COs retaliated against the respondents for simply having a conversation with the warden about the possibility of a grievance procedure. And this court in Ross versus Blake said that administrative remedies might not be available to prisoners if prison officials prevent them from using those procedures through intimidation, machination, or retaliation.
But counsel, isn't it true that respondents Love had actually exhausted her administrative remedies prior to the filing of the initial complaint with respect to her cruel and unusual treatment claim, her violation of Eighth Amendment with respect to her surgery? So clearly the remedy was available because respondent Love took advantage of it before the first filing. So how do you reconcile that with the absence of the grievance filing as to the first three causes of action in the original complaint?
Thank you for your question, Justice Waterman. In this case, the Eighth Amendment claim arose out of events that happened in 2016, in which the respondent Love asked for sexual reassignment surgery, was denied that surgery, and moreover, in that instance, the respondent was engaging primarily with Dr. Walsh and the prison's medical officials. While as my co-counsel will discuss later, Dr. Walsh's judgment should not be dispositive here. Dr. Walsh never beat or sodomized the respondents. The events that caused these later allegations, the failure to report, the rape and assault claims, these events occurred in 2018. And the grievances would have needed to be filed against the correctional officers. And it is the correctional officers who the respondents feared would retaliate, and feared rightly would retaliate, because the correctional officer—
But the warden, counsel, the warden is who would be responsible for all of the administrative remedies that would have been available to both Ms. Love and Ms. Storm. So the actions of the correction facility, that's the full purpose of filing a formal grievance, so that the warden can take proper administrative action against the persons who caused Ms. Storm and Ms. Love harm.
Thank you for your question, Chief Justice. In this case, the warden is primarily responsible for, in general, the prison's operation. But the reason that administrative remedies were exhausted when it came to Love's Eighth Amendment claim, but not exhausted when it came to the later claims that arose out of the events in 2018, the rape, assault, and failure to report claims, those claims were not available to the respondents. The warden, in an ideal world, the warden would be able to provide some kind of remedy to the respondents in order to alleviate them of the risk and the danger that the petitioners, the COs, posed to them while they were incarcerated. But the reality, what actually happened, doesn't support the assertion that the warden would have really actually protected the respondents. And in this case, the respondents were so afraid of the correctional officers that they were even too afraid to go through the grievance procedures that the warden laid out for them. In other words—
Counsel, isn't your stronger argument the argument respecting Rule 15 amendment, Rule 15 amendment, amended complaints? I mean, do you think that the circuit court was correct in saying that in the absence of, and we all know statutory construction, right? If the legislature wanted to do something like make a new statute subject to another statute, or change another statute like the federal rules of procedure, it would have said so. And so do you think the circuit court got it right that the Rule 15 amended complaint it supersede the original complaint, and therefore respondent Storm's status as of the date of the amended complaint should control to determine whether or not the statute, the PLR, applies?
Yes, Justice Waterman, that's exactly correct. In this case, while we may have a factual debate about whether or not administrative remedies were available, the issue that this court granted certiorari on is whether a complaint amended under Rule 15 supersedes the original complaint in terms of its timing. Therefore, when Storm filed her amended complaint after her release from prison, she was no longer a prisoner and therefore no longer subject to the requirements of the PLRA.
But counsel, wasn't the congressional intent behind establishing the PLRA to prevent the large number of filings by incarcerated persons without exhausting administrative remedies?
Yes, Madam Chief Justice. The PLRA was passed in order to, or this court noted in Porter v. Russell that the PLRA had two main functions. The first is to reduce the quantity and improve the quality of prisoner lawsuits. And the second is to provide prison officials with the opportunity to address grievances prior to them needing to be brought to court. In this case, the second point, the grievance procedures potentially curing the issue here, has been lost by the petitioner's own actions in retaliating against the respondents. With regard to the first purpose of the PLRA, the issue of judicial economy and potential frivolous complaints, the PLRA, as Justice Waterman points out, nowhere in the text of the PLRA does it say that Rule 15 is superseded. Is there any mention to amended complaints or supplemental complaints? And as this court stated in Jones versus Bach, the normal—
But when you look at the legislative history and congressional intent of the PLRA, counsel, it is to prevent exactly what Ms. Storm did. Not file a formal grievance and allow for administrative remedies to happen, wait until she was released from prison, file a supplemental complaint, understanding the rules, understanding the provisions of Rule 15, to circumvent and create a loophole in exactly what the PLRA was established to prevent.
Madam Chief Justice, in this case, the respondents are not attempting to create a loophole in the statutory language of the PLRA. What the respondents asked today is that this court apply the normal procedural practice of the Federal Rules of Civil Procedure. And to reiterate, if Congress had truly contemplated this specific issue of whether an amended complaint in a prisoner brought suit should or should not supersede the original complaint, in other words, if Congress wanted to supersede or override the normal operation of Rule 15, they would have done so explicitly. If they had done so explicitly, we wouldn't have the circuit court split that resulted in this case needing to be brought to this court at all. As the petitioners brought up, the 11th Circuit in Harris v. Gardner made the textual argument, as the petitioners did, that the plain meaning of the words "no action shall be brought" in the statute means that exhaustion was required at the time that the initial complaint was filed. But the Third Circuit in Garrett versus Wexford Health and the Ninth Circuit in Jackson versus Fong came to a completely different conclusion. Both of those circuits noted that it was this court in Jones versus Bach that said that the words "no action shall be..."
But counsel, the Fong case completely contradicts the express language in the PLRA. So how do we get around that? And you're citing that as persuasive authority for this court to adopt in ruling in your client's favor.
Madam Chief Justice, the Fong case does not contradict the purpose of the PLRA. Insofar as the PLRA was intended to prevent frivolous prisoner suits, Congress thought that prisoners had incentives to file frivolous suits that non-prisoners didn't have. In other words, we might understand the purpose of the PLRA as intentionally trying to differentiate between what is a prisoner brought lawsuit and what is a former prisoner brought lawsuit. In this case, Storm is indisputably not incarcerated. She is no longer a prisoner, and the PLRA was not contemplated to continue to apply to her. The PLRA itself says that exhaustion only is required for prisoners who are incarcerated in a jail, prison, or other facility. Since Storm is no longer incarcerated, the PLRA is not intended to apply to her.
At the time of the incident, counsel, was Ms. Storm incarcerated?
Excuse me, Madam Chief Justice, could you?
At the time of the incidents that are a part of this case, was Ms. Storm incarcerated?
At the time that the respondents were assaulted by the correctional officers, as both the respondents were incarcerated. Is that the incident you're referring to?
Yes, yes. So at the time of the severe beating after the verbal information to the warden, she was incarcerated.
Yes, Madam
Yes.
Chief. Yes.
And she remained incarcerated for a period of time before release.
Yes, Madam Chief Justice. But in
And
this,
so there was an opportunity to follow the correctional facility's grievance process and file a formal complaint to exhaust administrative remedies.
no, Madam Chief Justice, in this case, because of the petitioner's actions, the respondents had no administrative remedies truly available to them. Moreover, that the events that these claims arose from happened in prison is by definition.
How are there no administrative remedies available, counsel?
In this case, because the respondents spoke to the warden and only days later received retaliation by the correctional officers, those administrative remedies were not available to them.
But the warden explicitly told both Ms. Love and Ms. Storm that the only way that they could take action for the harassment that occurred, that they went and spoke with him about, is for them to file a formal grievance in accordance with the correctional facility's policy. And they did not do so. So the subsequent events, they didn't give the warden an opportunity to exhaust the administrative action or the administrative remedies available because they never filed the formal grievance. We don't know what remedies were available because your client did not follow the formal process for us to even find out.
In this case, Madam Chief Justice, the issue.
Council, I have a,
Justice Waterman, I can't hear you. Are you asking a question? I just want to make sure I'm able to hear.
I'm sorry. I think there was a question on the floor. I don't know that you actually answered the Chief Justice question, but I had a follow-up to that, and you've got to stop.
Madam Chief Justice, may I answer your question and briefly conclude?
You may answer Justice Waterman's question as well and then conclude.
Justice Waterman, would you like to ask your question now, or should I answer the Chief Justice's first?
Please answer Chief Justice question first. Thank you.
Sure. Madam Chief Justice, with regard to your question about whether or not the respondent should have filed the grievance procedure so that the warden may have been able to give them a remedy, the warden told the respondents of the formal grievance procedure that the prison had in order for the prison to provide remedies. What the respondents are asking today is for this court to grant them a remedy because the prison officials' own actions rendered the possibility of internal grievance procedures curing this problem impossible. That is why the respondents chose to file a claim in the first instance, because the prison officials, the petitioners, created circumstances that rendered administrative remedies unavailable and now want to use their own actions as a shield for liability for the injuries that they caused the respondents. As such, the respondents had to come to this court today in order to find relief. Justice Waterman, would you like to answer your question?
I just have a quick question. Thank you. In the Harris versus Garner case that you distinguished from Garrett and from Hong, did the Harris versus Garner case, did that involve an amended complaint, or was that just an initial complaint and some of the prisoners had been released during the pendency of the action? Was there an amended complaint involved in Harris?
Yes, Your Honor. In Harris, there was an amended complaint. The facts were similar to this case in that the prisoners the prisoners initiated and filed their initial complaint while incarcerated and then filed an amended complaint after their release from prison. But the reason why the Harris court's interpretation of the law should not be adopted by this court today is evidenced by what the courts in Fong and Garrett said, and what this court actually said in Jones versus Bach. The words "no action shall be brought" in the statutory language of the PLRA is, quote, boilerplate language. They say nothing about Congress's intent in the PLRA and shouldn't be interpreted as dispositive here. And for that reason, the respondents respectfully request that this court deny the petitioner's motion for dismissal. Thank you.
Thank you, counsel.
Good evening.
Good evening, counsel. How are you?
I'm good. Madam Chief Justice, may I proceed?
You may.
Thank you, Madam Chief Justice. May it please the court. My name is Miriam Mashenega, and as my co-counsel mentioned, I will be arguing the Eighth Amendment issue. This issue is about providing aid and redress to a transgendered woman whose life is continuously and egregiously affected by the petitioner's gross infringement of her Eighth Amendment rights by intentionally refusing to provide medical treatment that has been found to be effective and sometimes necessary. The Fourth and Seventh Circuits have even stated that refusing to administer SRS to a patient similar to my client who's suffering from gender dysmorphia is synonymous to and is as severe as withholding pain medication from a cancer patient. Thus, the court should find that the petitioner's refusal to provide SRS, given respondent Love's continued suffering, violated her Eighth Amendment protections. The test that the court today should rely upon to decide whether a state's denial of medical care violates the Eighth Amendment is from Estelle versus.
Counsel, this court has already established in Brennan that the Eighth Amendment obligations are fulfilled when a person incarcerated receives adequate food, clothing, shelter, and medical care. Adequate. So how is Ms. Love receiving hormone treatment, extensive counseling services, as well as other feminine products not adequate?
Thank you, Madam Chief Justice. Although it is correct that the case precedent states that all that prisons are required to set is adequate care, it is clear here from the persistent nature of this disorder, in addition to the severity of it, and the persisting symptoms of my client, that the medical care given was not adequate. This goes back to the first prong of the Estelle versus Gamble test, which states, in which petitioners also conceded, that gender dysmorphia is a clearly recognizable serious medical need involving substantial risk of harm. Due to that substantial risk of harm, when it is clear that the persisting symptoms are just that, persisting, and that nothing is done, that is why it is not adequate. And secondly, the second prong, which is also met here, because the petitioners knew of Love's specific risk and chose not to change the course of treatment or consider SRS, therefore acting with deliberate indifference, which is another reason why the Eighth Amendment here is actionable. So the major focus of the case at bar is whether the petitioners acted in violation of the Eighth Amendment by being deliberately indifferent to a serious medical need.
Counsel, do you agree that this area of medicine, this area of psychology is in flux and it continues to grow and develop? Do you agree?
Yes, Your Honor.
So how is the court to determine whether the prison in this case, the petitioners in this case, acted with deliberate indifference if there's no clear guideline as to what the medical profession would have be adequate treatment?
Yes, Your Honor. It is clear that there's evolving standards within this case and also within the courts. And that is especially why standards such as the WPATH standards should be persuasive here. In addition to that, although there's not too much case precedent that is serving as guidance for this case, we do know what deliberate indifference means. And that is set out in Farmer versus Brennan. Deliberate indifference contains two parts. First, that the state knew of the substantial risk of serious harm. And second, that the state knowingly disregarded that risk. Farmer established that whether officials knew of the risk of serious harm is a factual question demonstrated by inference from circumstantial evidence. That evidence is clear here. Additionally, there actually is guidance from the case precedent. The case precedent from Edmo was a case that found that SRS was found to be appropriate. It should also be highlighted that this Supreme Court just mere months ago denied cert regarding the case of Edmo, proving that this court agreed with Edmo. And in that case, the Ninth Circuit relied on three core facts that are identically mirrored here. First, the attending doctor knew that the plaintiff, a transgendered woman, was diagnosed with GD. Secondly, this attending physician knew that the plaintiff had attempted self-castration. And third, the doctor knew that the plaintiff experienced persisting symptoms. As I mentioned before, these facts are identically mirrored here. Here, my client was diagnosed with GD while at BCI and with the knowledge of the prison officials. Secondly, Love has threatened to self-castrate on multiple occasions, again, with the knowledge of the prison officials. And thirdly, Love's threats continue despite a GD treatment plan that include hormonal treatment. And that goes back to your question, Madam Chief Justice. Not only was the symptoms persisting, but the GD treatment plan was clearly not working and the prison officials chose to do nothing. The shocking similarities between the two cases.
But counsel, they did do something. They are continuing treatment and care for Ms. Love in accordance with their established policy.
Yes, Madam Chief Justice, they did offer some treatments. As the petitioner noted, the prison officials offered hormonal treatment, makeups, and garments. And I would like to acknowledge that makeup and undergarments do nothing when you do not identify with the body that you're in. Yes, in addition to that, the hormonal treatment and the mental health counseling was clearly and egregiously not working. As I mentioned before, my client had expressed suicidal ideations. In addition to that, they expressed the desire to self-castrate. That is why the court—
Counsel, petitioner brought up a point about the counseling and the hormone therapy taking up to 5 years to work. We're not at the 5th year. So how can we say that the petitioners have acted in an egregious manner in not providing SRS?
Madam Chief Justice, it is correct that some guidelines state that SRS should be provided potentially after 5 years if it's not working. However, in the severity of this case, that would be being the decision to wait for my respondent to go ahead and actually attempt self-castration or to go ahead with the things that they're expressing would be the exact response to us waiting. We do not want to wait for something severe to happen. We do not want to wait for bloodshed. And that is why, although it is correct that some guidelines had stated that, yes, there must be 5, 6, 7, at least these amount of times.
But counsel, your client, Ms. Love, has identified as a female since she was 11 years old. And she was diagnosed with gender dysphoria in 2016. We're now in 2021, and she has not self-castrated or committed suicide. So the treatment plan that was established at the time of the GD diagnosis is working because she hasn't self-castrated as threatened.
No, Madam Chief Justice, I would argue that the treatment plan is not working. As you mentioned before, my client, since they were 11 until 23, has identified as being a woman. Not only does that show the severity of this this case, it also shows that before they were incarcerated, they had the resources, they had the ability to do whatever it was that my client needed to do to identify as a woman. However, now that they have given themselves to the
Counsel, that's to my point. She has identified as female since 11 years old. So prior to incarceration, she had the resources and she had the ability to get SRS prior to incarceration. So why is it such a grave concern now that she's incarcerated and it would be at the expense of the state?
Yes, Your Honor. And as stated in Brown versus Plata, the reason why it's such a severity now is because of the prison. My client has directly given herself to the prison, directly given her desires and the ability to get care from the prison. And by the prison refusing to give that care, that is why it's so severe. Yes, it is clear my client could have easily done this before. However, we are not able to infer what her financial status was beforehand or why she did not do it. But what we can focus on is why this prison officials did not provide it and how that was deliberate and different.
Counsel, I have two questions unrelated. The first is, are you asking us to craft, as I asked your adversary, a hard and fast rule respecting deliberate indifference, and whether or not this court or other courts should consider the WPATH recommendation as the medical expert, the standard by which all of these cases should be judged? And then I'll ask, if you answer that, then I have a second question.
Sure, Your Honor. It is clear that whatever the court decides to rule today will serve as case precedent. However, it should be stated that what we're asking for today is not a universal deliberate indifference should be made up today. What we're asking the court to look at is what deliberate indifference has been set out to be in the case precedent. As I mentioned, deliberate indifference has to do with the fact and the knowledge of the prison officials to know that the care wasn't adequate, and with that care, disregarding it. And as I mentioned, that is clearly here today.
So you agree with the circuit court that the case should be remanded back to the district court with an eye towards developing the facts as to whether or not there were deliberate indifference given the various evidence?
Yes, Your Honor.
Okay. I just had one other quick question because it was touched upon by the district court, and I'm wondering what your position is, whether or not the circuit court touched upon it, whether or not the district court improperly considered the prison's argument that there was supposed to be a balancing between the safety of prisoners against your client's freedom from cruel and unusual treatment. Was that an improper standard to view this case?
Yeah, just to make sure I'm understanding your question, are you asking, should the courts look at the fact that there might be security issues posed if my client is given SRS because she's in an all-male prison?
Yes, and whether or not that should even be part of an assessment as to whether or not the prison violated her Eighth Amendment rights in the way alleged.
Yes, Your Honor. Although I do agree that is a pertinent point, it should not be the crux of the issue today. The crux of the issue is proving not only that the prison officials were deliberate indifference, but that my client's Eighth Amendment rights were violated. Although it is a very valid statement, it is not enough. Even it is found that there will be security issues. It's not enough for my client to not be given this surgery. And that goes on to my next point. The petitioners had subjective and objective knowledge and acted with gross negligence in disregarding that risk. For the subjective knowledge prong, the petitioners argue that the prison went above and beyond by providing undergarments and makeups. And in addition to that, the petitioners also argue that the medical treatment given to my client was helpful and that it was adequate. This cannot be so. The prison officials had the subjective knowledge, and it was indicated by the evidence that despite receiving mental health counseling and hormonal treatment, the respondent continued to have persistent symptoms. This case is similar to Gobert versus Lee County, which found that the information in Gobert's complaint gave Captain Weaver abundant reason to believe that her medical need was serious and that it was so obvious that even a lay person would recognize the necessity of medical treatment. Here, a lay person, the prison doctors, and the guards who played a substantial role in harassing my client had the subjective and subjective knowledge. And that brings me back to the second point of this argument about the objective knowledge.
Counsel, I'd like for you to move on to the third point, which is what I'm trying to wrap my head around, and that's gross negligence.
Yes, Madam Chief Justice, thank you. Petitioners were aware of the egregious harm and more than grossly disregarded this risk. Although it is clear that gross negligence is a high bar, the petitioners here have remarkably met it. The court in Farrow found that deliberate indifference violates the Eighth Amendment, regardless of whether the indifference is manifested by prison doctors in response to prison needs or by prison guards in intentionally denying or delaying access to medical care. Here, both scenarios occurred. Not only did the prison guards play a role in the respondents' intensified negative emotion via sodomization and physical and verbal harassment, the prison doctors of BCI evidently refused multiple requests for medical care from the respondent. This idea of gross negligence.
Counsel, they haven't refused medical care. They just haven't given Ms. Love the care that she desires, which is SRS. And SRS is also listed as a last resort treatment option under WPATH.
Yes, Madam Chief Justice, to your first point, although this is a request from the respondent, this care is not preferential, it is essential. As stated before, the persistent symptoms are severe enough where the only next step is SRS. And as you mentioned before, WPATH had verbatim called SRS a last resort treatment. It is clear that we are at that point of last resort. As mentioned in the argument.
What evidence do we have other than your client's assertion of self-castration and suicidal ideations that we're at the last resort where SRS is a viable option?
Your Honor, in addition to the suicidal ideation and the expression of desire to self-castrate, as stated in my argument before, this case is synonymous to and equal to the Edmo case, where the Supreme Court did find that SRS was appropriate. And that is why today the court should find that SRS is appropriate. As I mentioned, the facts in the case at bar identically mirror the facts at Edmo. And in Edmo, that plaintiff was at that last resort statement. They attempted castration. They expressed their desire to commit suicide.
Well, your client, so let's distinguish that based on the facts. Your client hasn't attempted, she's only threatened. So that's a significant difference in the treatment and the care and SRS being assigned. Ms. Love has only threatened self-castration. In the case that you're arguing supports the facts and circumstances in favor of your client, they actually attempted.
Yes, Madam Chief Justice, thank you for that distinction. However, this distinction is a difference that should not have too much relevance on the case at bar. If we were to argue that this distinction is relevant and severe enough, this would be arguing that we should wait until my client actually does perform self-castrations. The courts and the justice systems, I do not believe, would want to wait for bloodshed before making actual contact, before doing what is correct for the patient. And the WPATH standard said that we should look at this at a case-by-case unique basis. It is clear from the necessity and the severity of this case that this unique basis has been met. Madam Chief Justice, may I have enough time to briefly conclude?
You may.
Your Honors, the conclusion today is twofold: legal and moral. Legally, there's simply an abundance of evidence to show that the Eighth Amendment is not only actionable here, but has been violated. And morally, the case at bar is one of transparency and clarity. By deciding to rule against my client today, the court may set a precedent that states that not only are prison institutions free to refuse even the most basic and necessary medical care, but it will highlight that the courts are declaring that the rights of transgender citizens and all the perceived differences should be disregarded for the sake of convenience. For these reasons, we ask the court to deny the petitioner's request for summary judgment and deny the motion to dismiss. Thank you.
Thank you, counsel.
At this time, the petitioners have a rebuttal, and I am setting the clock for 2 minutes. So when you're ready, you may proceed.
Madam Chief Justice, may I proceed?
You may.
Madam Chief Justice, we'd like to point out points for both issues. Quickly, as a note for issue number 2, respondent has repeatedly referred to respondent's condition as gender dysmorphia. Respondent's condition is called gender dysphoria, and it is important that we are clear about the serious medical need at hand. Also, respondent has repeatedly contended that Edmo is controlling. Edmo is a substantively distinct case. In Edmo, the inmate had been receiving hormone replacement therapy for 7 years without a change in her condition, and her social transition to womanhood was not supported by the prison to nearly the same extent that Love's social transition had been here at BCI. But regarding the first issue and the amended complaint, Ms. Kong asserts that we should adopt the decision in Garrett versus Wexford Health, but the facts of that case involved substantial changes made to the initial complaint. Nothing of the such occurred in this case. But more importantly, the amended complaint cannot render the original complaint of no legal effect because we would be essentially validating Rule 15C, which stands for the proposition that timing of a complaint is important for purposes of limitations in civil actions. And it's important because the judicial system is one of fairly limited resources. Your Honor, in the year 2015, prisoners filed more than 27,000 civil rights and prison condition cases, which accounted for 10% of the district court civil docket, and for which 92% were filed pro se. To place this in context, many chief judges have asserted that prison litigation cases in their court only receive an hour of their time from time of filing to deposition, So allowing this case to proceed and every other case that would certainly follow would not only contradict the laws that most of our elected officials enacted, but also the legislative intent for which the PLRA was enacted to begin with. The definition of justice does not end with these respondents or with BCI. In fact, the respondents can refile their claim and we encourage them to do so. But the Prison Litigation Reform Act is our governing law, and we cannot assume the role of a legislator, and much less when the law is plain and clear. Thank you.
Thank you, counsel.
Thank you to the competitors for presenting their arguments. At this time, I will be moving our judges to chambers where they will deliberate. After such time, I will move them back into this main virtual courtroom to offer feedback. So just give me one moment.
All right, good afternoon, ladies. Before I begin with individual feedback, I just want to compliment all of you on the outstanding job and advocacy skills that you displayed this evening during the competition. Both Judge Waterman and I were extremely impressed with your legal acumen, with your poise and presence during arguments, your respect and decorum to the justices when we were going through each argument. So great job to all of you. And regardless of who the winner is, I know that you all are going to be outstanding attorneys and advocates as you continue in your law school endeavors and potentially and future practice of law. So with that, I am going to move into comments. We'll start with the petitioners. Ms. Sanchez, I thought you did a really good job, a great job. Everyone did a great job. So if I say good and great, don't take that as a slight. They're interchangeable during these comments. But I thought you did a really great job of not allowing me to take you down the rabbit hole of dealing with the facts of the case, because that wasn't why we were here. We were dealing with whether or not the complaint was sufficient, and because they did not file the formal grievance and follow the PLRA process as required. So the fact that you kept refocusing the attention back to the nuts and bolts of the argument, that's really good. And that's just a comment for everyone. If you all move forward to the national competition and compete, even though the judges may take you down one arena, definitely answer their questions, but redirect them to the crux of the reason why we're at the court and you all are arguing before the justices. So I thought you did a really good job with that. In your rebuttal, you talked about addressing 2 points and you focused on one for a really long time. And it was directly related to the strength of your argument. And that's okay, that's a good thing. But when you're doing a rebuttal and I hear, I'm gonna address 2 points, try and give equal time to both of those points that you're going to discuss. Judge Waterman, Justice Waterman, ma'am.
Thank you. I appreciate that. Thank you, Major. I mirror, first of all, the general comments of the Major that you're all going to be wildly successful. You have presented yourselves here tonight in this virtual setting better than some attorneys do sometimes in my courtroom. Major might be able to, I don't know if you want to comment on that, but you had a mastery of the facts, you had a mastery of the law, the specific law that addressed each of your issues, and you presented with so much professionalism. You should be proud. And it was an honor to actually witness this. And so that's a general comment that applies to each and every one of you. With respect to specifically to Ms. Sanchez, I agree with everything that the major has said. The one thing that I kept trying to get you to do was answer my question. You eventually did, but you could have done it a little earlier. So that's just something to be mindful of, because your answer was the answer. I mean, it was the best, it was the answer based upon the record and the governing law. And that was really it. With respect to the rebuttal too, I agree with the major that you wanna balance the time, because you don't want to restate something that you said in your main argument, because your main argument was focused. I have here respectful, you addressed the issues, you were confident, right? Sometimes even we have to pretend to be confident, smoke and mirrors, right? But always respectful. And it's never a bad thing to take a pause, to consider the course question, and then answer it. There was one thing on your arguments. I think you said on the refiling of cases, you were talking about the court's dockets. I think there was a little bit of a flaw in the argument, because the folks are going to refile anyway. You know what I mean? So, but in any event, it was terrific, and just answer the question. And then, like, you always had a great way of focusing it back. So that would be the only thing I would say to work on as a work on. That's it.
Okay, Ms. Jones, firm grasp of the facts of the case, the legal authorities to support your argument were all really good. Your tone and tenor, demeanor, respect towards the court were really good and effective. You answered the questions asked of you by the justices, and I think that's all I had. You did a really good job with your argument overall.
I agree. You definitely stayed sharp. You definitely stayed respectful. I feel like I'm the bearer of bad news, Major. Not that it's a bad news, and you'll forgive me. There was one thing that, I'm sure I've done it a million times when I've argued before the appellate division, where I got frustrated with the court's question and I let out a sigh, or, I'm very emotive as it is. So there was a little moment of frustration that was indicated during your argument. Now, I didn't take any personal affront to it, and neither did the major, but trust and believe that there's a judge out there that will. So just be mindful of that. So that's really just a point of something. I think that the comments, at least that I'm making, and I know that the major is making, it's just something to work on. Like, you're already, at a level of a certain excellence, and now this is just the polishing. These are just the things that you'll want to be mindful of. But you did really well, because we were laughing, the major and I, and Miss Smith, we just put you through it. You guys didn't have a break. That's called a hot bench, and you did very well. So just, if you get frustrated at the judge, on the inside, you can cuss them out, you can bite your tongue, but don't let it show. That's all I have to say on that.
Ms. Kong, again, I'll reiterate, great job on your argument, your analysis with regard to the facts. And I think what was critically important with your position, because you were at a disadvantage with regard to the law and policy, is that your familiarity with the facts of the case and humanizing the incidents that occurred when Ms. Storm was incarcerated, which prevented filing the formal grievance. Those are critical points and very important to bring up, because if we had to make a determination just based on the law as stated, the policies as written, then of course, your client did not follow the process and the procedures and all of those things. But humanizing the incidents that occurred when they tried to do so is really an important factor. And the only feedback that I would have is try and incorporate some law if you can, because there were a couple of cases that are in your favor a little bit. So just incorporate those a little bit more as you move forward to strengthen the facts and bolster them and make your argument even more effective than what it was.
Trying to unmute. Okay, thank you. I agree with the major 100%. I just want to add that I tried to get you on the that one of the respondent, and I'm sorry, I was conflating the names, that Love had actually engaged in the grievance procedure with respect to her 8th Amendment claim. And you did really well. You were like, no, but that doesn't, it's a different circumstance. It was 2 years before, and piggybacking or what the major was saying, that in the 2018 incident with the rape and the excessive force, it was a totally different situation. So that was well done on that in a way that humanized. See, and I agree that the respondents actually, I thought the respondents actually had the stronger case for a number of reasons, but most importantly, because you had 2 humans versus the prison system. So it's easy to humanize, and you did that, and you took advantage of that, and you told the story of the respondents. Whereas the petitioners, really, you're just gotta, you're sort of relying on the law and the fact, and we're doing this, and we're trying to, have an effective system of justice, and we don't want to have a bazillion claims in the court. So you did very well in that regard, Ms. Kong.
I need you to please pronounce your last name because I do not want to mispronounce it before I give feedback.
It's okay, Asheniga.
Okay, Ms. Asheniga, you did a really good job, similar to Ms. Kong, in humanizing the aspects of your client's position in this case. One of the things that I wrote down and we discussed in deliberations, and actually Ms. Smith brought it up, was when you said, do we wait for bloodshed? Because I kept talking about, there was threats of self-castration, that he didn't actually attempt to do it, and that's the distinguishing factor. And so bringing that to light, and at the end, when you conclude with, this is a legal and moral basis, and you explain both, but your familiarity with the case law supporting the facts was really good. Your ability to respond to questions and refocus your argument back to what you wanted to discuss was good as well. My only critique would be slow down. And I think it's because you knew that we were a hot bench, and you heard us interjecting with the other competitors before you. So you were like, okay, I have to speak fast to make sure I get out everything that I want to say. But it is okay if you don't get out your full argument, because the advocacy piece, and one of the critical benefits of being an effective advocate, is addressing the matters that the judge, that the justices care about. And so even if you don't complete your argument, it is perfectly fine, because we're going to ask you questions to prompt what we want to talk about. And so oftentimes you'll run into justices or judges who don't have any questions, and you can get your full argument out, or they don't want to talk about anything that you may have prepared, and everything that you've done, the weeks that you've spent, you may feel like are in vain, but it's not, because it's that preparation that allows for you to be able to effectively answer the questions that are posed to you. Those are my comments. Justice Waterman, Judge Waterman.
I again 100% agree with the major, and yeah, my thing to work on, Ms. Asheniga, is slow it down. But I imagine, like, you got into the room and you were ready to run, because as I said, we didn't make it easy for you all. And so all of you performing at the level that you did, and staying focused, and not getting confused with your facts or what you wanted to say, was really just wonderful, and a terrific demonstration of your understanding of what we do as lawyers and how you present a case. So that would be my only suggestion, Mr. Asheniga, that just be mindful. And if you feel like, when I used to argue in the appellate division down here in New York, sometimes I would just go and take a moment in the bathroom and, you know, and like say a little prayer meditation or what have you, because my heart would be beating so fast, and that makes you go faster. So, you know, just to get a sense of gathering myself. And you can do that even in the middle of an argument, right? Like even if you feel like you're starting to spin out, you can take a moment and gather. It's never a bad idea to take a pause. It's fine. The judges understand that as well. But, you know, well done, for sure. And you also very much humanized the respondents. Got a sense of who they were for sure.
Thank you.
Well, thank you so much to the competitors. I hope you guys felt that this was a great experience. Just watching you all, I was even impressed. So thank you so much for being a part of this. Coaches, thank you so much for being here. And of course, to the judges, Judge Waterman, Major Crawford, thank you so much for being here, for sharing your personal experiences and giving this great feedback. It's invaluable, and I'm sure the competitors feel the same. And this pretty much concludes our virtual competition. So congratulations, everyone.
Well done, well done.
Well done.